Hello and welcome back to the Data Privacy Lawyer. My name is Funmi Owolabi and I'm the principal attorney at the firm. Today's review is going to be on some AI terms. So we're going to look at the impact of privacy on these terms. There's lots of different legal factors that go into artificial intelligence, one of which is privacy. So there's this organization, let's just hover over the products. So they've got an AI-powered Drupal CMS, a platform built for stronger Drupal applications. Create, manage, and update your websites from one spot. Single source to store and manage organization-wide creative assets. Okay. All right, so something to do with e-commerce. You can do content, optimize, and activate. So the reason I just hovered over the products is because I wanted to see if there were some initial clues that I could gather based on how AI may interact with the products and what type of personal data may be in scope. So at a minimum, we're going to have some users. I didn't see any other clues about maybe federal privacy laws that might be implicated, but without having true insight into each of these products and tools, I can make some presumptions based on some of the language that's utilized in these terms, and then also the description that's provided by the organization and what customers may be signing up for when they use artificial intelligence with this provider. So this was last updated in 2024. The question that I generally have when I see these AI terms that were drafted at this time is, since this period, there have been many AI legislation that have come out not just in the United States, but in other geographies. And those could impact how a business rolls out its AI solution. Now, the reason I mention this is because legislation matters. And I'll give you an example. The legislation in California dictates that businesses have a button at the bottom of their websites that say, "Do not sell or share my personal information," allowing California residents to opt out of that type of activity when it comes to their personal data. That impacts businesses that process California residents' information, right? And when that gets rolled out, the business needs to oblige and fulfill its obligations under that legislation if it meets the threshold. The reason why I've highlighted this date is, has the business considered whether the artificial intelligence legislation that has come out in certain geographies where they may be implicated based on their products and solutions, has that been reflected in these terms? It's really important for all businesses to look at what legislation impacts my business and update their public-facing documents as and when the legislation is rolled out, because it could implicate your obligations and the disclaimers and provisions you place in your terms. So I say periodically, loosely, because depending on your industry, the period in which you update your terms could be smaller or larger depending on the type of personal data or AI that's utilized. Now, the reason it's really valuable to have a privacy counsel review your terms is because in 2026, it's impossible to do business without personal data. Personal data impacts every aspect of your organization, whether you like it or not. And there are laws around how you can use personal data. Now, the consequences of not adhering to those laws is you could be issued an enforcement action, and it could be a fine, and it could be costly for your business. So you need to make sure that you are putting in place the appropriate compliance mechanisms to ensure that you're adhering to those laws because your business literally relies on it. I don't want to dwell too much on that, but I do think it's valuable to mention because I've been doing lots of reviews on this channel. I think that many businesses aren't aware of what needs to be done. And that's why it's really important to seek counsel. So let's get into these terms. When using the AI features, users, so we already know there's personal information because we've got users, right? I am a user on this website. I am just browsing the website. I'm hovering over products and solutions, and I have personal data. Now, I don't know if you recall, if you scroll back to the beginning of this video, you saw that there was a cookie banner here. And I had the opportunity to opt out of certain cookies being collected as I interact with the site. Cookies are considered personal data because they identify an individual. Now, I'm going somewhere with this discussion. The reason it's really important to note that is when you have a user or when you have an individual, there's going to be personal data because the definition of personal data covers anything that identifies an individual, which is why we saw that cookie banner, and I exercised my preferences. There are going to be users who use the generative AI features. Now, I don't know what their AI tool is. I would need further insight into that. But if there's users, at a minimum, the AI feature is going to collect this user's name. I don't know any AI tools or AI applications or any AI at all that doesn't at least obtain the name of who the user is when the feature is offered. In addition to that, we can see that when using these AI features, the user may upload content such as an audio file. Now, if you've been watching my videos for a while now, you know that an audio recording can identify an individual. Same with a video, right? If you've watched any of my TikToks or if you've watched any of my LinkedIn videos, you're able to identify that, oh, that's the principal attorney at the Data Privacy Lawyer, right? You're able to identify me. If you're inputting that into the AI features belonging to this organization, there's two things of note. One, they are processing personal data, right? Because processing is any operation or set of operations on personal data. So we know that for a fact, they are going to process personal information. Now, who do these users belong to? Are these users employees at business? Are these users at a company A, right? So essentially, company A is procuring the use or procuring this solution from this organization. And then they allow their employees to input this type of information, which is considered personal data. So there's a responsibility on company A's users because company A has obligations under the data protection laws. In addition to that, this business has obligations as what's considered a data processor because their AI feature processes this type of information that could constitute personal data, right? And they've said here it collectively has input. So two things of note. One, they need to have a privacy program because we can see here that they process personal data. In addition to that, company A's users also needs to have a privacy program because they're providing this type of insight to this third party for a service. So they determine the means and purpose of processing because they have procured this solution. So I think that's valuable to note because we can see that there is definitely personal data implicated, even though this relates to artificial intelligence. There's lots of different legal ramifications outside of privacy, but at a minimum, there is personal data being processed that comes with responsibility. So the last thing I'm going to talk about today is this sentence, customer responsibility. Customer is solely responsible for the creation and use of the output and for ensuring the output complies with the terms. However, this company may use available technologies, vendors, or processes to screen for and block output that may violate applicable law. So I wanted to talk about this sentence because if you are, let's say, for example, you're considering working with this organization, you have the opportunity to review their practices prior to engaging with them contractually, right? If you have a privacy program and you're the customer, you're a business company A, right? And you're like, hey, I'm considering working with this entity in order to obtain their solution. Let's see. Let's say, for example, content, Acquia source. You can see if their practices when it comes to their terms is something that you can agree to based on the provisions in their terms. Is this acceptable based on our own AI stance? Is this acceptable based on our privacy program right now? If it is, then you know what to do. If it is not, at least you've had the opportunity to review the terms. But I think the value in this discussion is knowing that the use of AI implicates privacy. And when it does, you need to make sure that it aligns with your privacy program and your risk appetite. So I really hope you enjoyed this review. If you have comments about what I've discussed, leave a comment below and I will see you in another one.